Now we're going to turn things over to Karen McGee, who's going to give us an update on the pending litigation against the EPA, which is the third prong of the Flint water crisis litigation.
Thank you, Beth, and good evening, everybody. Thank you so much for taking the time to be with us tonight. I'm going to talk to you about our efforts to make sure that all individuals and all entities are held accountable for the Flint water crisis that has affected your lives so much. We've been talking about the partial settlement in the class action case that we have against the state and state actors and the city of Flint and an engineering company. But in an effort to make sure that all entities and individuals are held accountable, we also filed a lawsuit against the United States government, specifically the Environmental Protection Agency, which is referred to as the EPA. And I want to give you a brief summary of the status of that case. That case has not been resolved and is currently in active litigation. In 2016, we filed a lawsuit against the EPA, alleging that they violated the Federal Tort Claims Act when it negligently responded to the Flint water crisis by, among other things, failing to timely warn Flint water users of the health risks posed by using the water. The damages that we're seeking in that particular case are very similar to the damages that we're seeking in the class action case, and that is for personal injury, wrongful death, property damage, and business loss. The case has been assigned to a federal judge in Michigan, Judge Linda Parker, a very thoughtful jurist. We're very happy with her selection and the work that she's done thus far in the case. After we filed the lawsuit, the EPA filed a motion to dismiss the case, alleging that the plaintiffs cannot prove that it was negligent based on certain governmental immunity protections. I just want to tell you, it's extremely difficult to sue the US government, okay? There are governmental immunity protections that they have. And I want to say that we were successful in responding to the motion to dismiss by the EPA, and that Judge Parker agreed with our arguments and denied their motion to dismiss. And she ordered that the case proceed to trial. This was a huge victory for us and quite remarkable. In a case against the United States government, you're not entitled to a jury. You instead get what is called a bench trial. And a bench trial means that the judge is the individual who actually acts as both the trier and finder of fact and of law. And so Judge Parker will be presiding over the trial in this case. There are over 7,000 plaintiffs who are part of this lawsuit, and including another lawsuit that was filed by a team of other attorneys that has been consolidated with the case against, the case in front of Judge Parker. So we have more than 7,000 plaintiffs who are part of the case against the EPA. Since there's so many individuals who have filed claims against the EPA, the parties agreed to proceed to trial with the sampling of claims from which Judge Parker will decide liability and damages. This is what's called a bellwether trial. This is just the first trial, and the outcome will give the parties an idea of how future trials will go in terms of findings of liability and damages. This is typical in a process in a case where there's over 1,000 plaintiffs, and it's just not practical to try all of the cases at one time. So toward that end, the parties selected, first of all, 7 different damage categories to present to the court at trial. And these damage categories are claims for personal injury to young children, children 6 and under. Another damage category is personal injuries to older children, 7 and older. The third category is personal injury to adults. The fourth category is personal injuries causing death. The fifth category is property damage claims The sixth category is business loss claims. And the seventh category addresses issues related to the timeliness of certain individual claims. So there's 7 different damage categories. And we determined, the parties agreed that there would be a total of 14 plaintiffs in the first bellwether trial. 2 plaintiffs would represent each of the damage categories. And to be fair, each party got to pick 1 plaintiff for each category. So the plaintiffs got to pick 1 for damage category 1, and the EPA got to pick 1 plaintiff for that category. And that was the same for each of the 7 categories, for a total of 14 plaintiffs. We recently completed that selection process. And so we now have selected 14 plaintiffs who will proceed to the first bellwether trial. Since we've now selected those 14 individuals, we have entered the phase called discovery in the case. The discovery phase of a case is the stage where the parties exchange documents, they share information so that each has an opportunity to fairly present their case at trial. Discovery also includes depositions of witnesses and parties. Depositions are oral statements taken under oath. And so we're beginning that phase of the case in preparation for the trial. That process takes some time. There's many thousands, hundreds of thousands of documents involved in this case, and there will be many depositions taken as well. We've not yet determined the deadlines for discovery or a date for the first trial. We have a status conference scheduled with Judge Parker later this month. And at that time, dates will be set by the judge that will provide the parties with an understanding of when they need to get things done and when the first trial will start. We don't anticipate that the first trial will take place before the end of 2022, and maybe not perhaps until 2023, based on the work that will be needed before trial. If you've been selected as one of the 14 plaintiffs, we just did the selections recently, you will be notified within the next 10 days. And we've talked to everybody who was being considered for a selection, so those individuals know that they may have been selected, and we're going to tell them finally that actually they have been selected. And so we'll be reaching out to you shortly on that. We're very committed to pursuing this case against the United States government. We know that it is a challenge to sue the United States government, but we're up for the task. We want to hold them accountable for their failures in this case and the damage that resulted to you because of that. In order, you should know this, and this is on the slide that you're probably looking at right now, that in order to sue the EPA under the Federal Tort Claims Act, you must file a claim within 2 years of the violation. It's not like a class action. It's different. The time to file has now passed. And so if you did not file a claim, you can't participate in the case against the EPA. However, you still remain part of the class, and the class action for which we've reached a partial settlement, which we've talked about in terms of the claims process. In addition, you still stay part of the class action against the engineering companies that has not been resolved. And so you still have active claims in those cases, but you cannot participate in the EPA case at this point because the time to do that has passed. So I thank you for your time. We look forward to continuing to fight for you and get justice for you.
Thank you, Carrie. That was very informative about the other litigation that is ongoing. Appreciate that.